Hello, everybody. Welcome to Law and Society. Today, we're going to talk about SCOTUS on the issue of birthright citizenship slash judicial authority, and also its ruling in the removal case in the, I believe this is the AARP case, if I'm not mistaken. Yeah. So, first with the oral arguments. Now, keep in mind that the oral arguments happen in a very haphazard way. But the premise, the issue that was brought up in front of the Supreme Court was not about the merits of the case, which is whether or not Donald Trump's executive order is in conflict with the 14th Amendment's birthright citizenship clause, and also other Supreme Court precedent that has supported and expanded on birthright citizenship. That is the merits of the case. But what Donald Trump's government lawyer was arguing was that the injunction that the judge in this case put on stopping the execution of that birthright citizenship executive order, whether that order itself was a universal injunction or not. And the government contends that it is not, and that it only applies to the plaintiff at hand. But here's something that the respondent said that is important. That, I don't know if the respondents said that or not, but respondents would welcome if there would be a briefing on the merits, because the merits are embedded in the nature of the injunction. So what that means is, and this is what Justice Sotomayor talked about during the questioning of Mr. Sauer, General Sauer. By the way, General Sauer is the same, is Donald's defense appellate attorney while he was contesting his criminal indictments in the federal cases. So Mr. Sauer is in a position of power now, and I think that's worth mentioning. And Justice Thomas spoke of the history of of these universal injunctions, and he commented that we survived until the 1960s without universal injunctions, and universal injunctions happened in the history of universal injunction with Bill of Peace, tax collection injunctions, and the most recent is the AARP case, which will be discussing in this final ruling. So it's no surprise that Thomas dissented in the AARP case, but he's focused on the history of it because he wants to find a reasoning to say that this is not part of, the custom of the judiciary it is not the history and tradition of the judiciary to issue these universal injunctions. But the other side of the argument is that this injunction is tied to the merits of the case, simply because, and Justice Sotomayor talked about this, that if you don't have, say for example, the government's position that the 14th Amendment's Citizenship Clause applies to children of former slaves, not the children of illegal aliens. There are laws other than the 14th Amendment, SCOTUS precedent, 4 SCOTUS precedents that actually support the idea that even if the parents are illegally in the United States, if you are born there, born in the United States, you are a citizen of the United States. So the executive order violates, much like what the executive order would violate in the AARP case, which is the due process of law under 4th, 5th, and 6th Amendments. In this case, the executive order violates the law under the 14th Amendment and then several SCOTUS precedents. So if and when you issue a preliminary injunction, it looks at the merits of the case, and one big question is whether the case will likely succeed on the merits or not. And if there's a question of whether it would succeed on the merits, then the court puts an injunction on it so as to not hastily go into making a ruling about that particular issue. So here, the issue is how the executive order, the merits of the case, violates an established constitutional right. And Justice Sotomayor, or I don't remember if it was Justice Sotomayor or Justice Kagan, talked about, I think it was Justice Sotomayor, talked about how, what if the government just came in one day and took away your guns? Like, when you made a ruling on one person, say a district court applied or issued an injunction stopping the government from going, and I'm extrapolating on this hypothetical because that wasn't done in the quick parlance of how the arguments happen. So if there was that preliminary injunction on that prohibition of application to take away guns, would that apply to just that person who brings the case? Or would that apply to the right to bear arms to begin with? So the position of the government is the opposite, that it would have to deal with only that person who brings up that cause of action that contests the government taking your right to guns away. So here, the precedents, here the executive orders violate the Constitution, just like it would violate the Constitution's Second Amendment if there was such an executive order that said take everybody's guns away. In the same way, as in the AARP case, where you are being deprived of due process of law, which is violation of the due process, 4th, 5th, and 6th due process components of our amendments, laws of the land. In the same way, in this case, the executive order violates direct federal constitutional words, as well as law that the Supreme Court has interpreted from the 14th Amendment, where it says that even if your parents are illegally in the United States, if you are born in the United States, you are a citizen of the United States. Well, Mr. Sauer contends that. The government actually is saying, no, we're saying that the 14th Amendment was only meant for the children of former slaves and not for illegal aliens, is sort of parsing what the 14th Amendment Citizenship Clause actually says. Which says anybody who is born in the United States and is subject to the jurisdiction thereof is a citizen of that jurisdiction. And the minute you are born in the United States, you are subject to the jurisdiction and the laws of the United States that governs your infancy and taking care of you as a living being, as a human being. So this case about birthright citizenship, the questioning seemed as though the conservative justices were resting on what would be the outcome if there was a class action, if this was brought up as a class action, you know. And one justice asked the respondents that, you know, what would you say about an expeditious merit hearing? And you know, they said that the respondent said that they would welcome it, and SCOTUS could schedule a hearing tomorrow, and that would become binding precedent from this court. So the respondents are saying that the permanent injunction is interlaced with the executive order, the substance of the executive order, because it directly contravenes the Constitution. And Sauer's position, the government's position, is that it doesn't contravene the Constitution because the 14th Amendment doesn't apply to illegal aliens, children of illegal aliens who were born in the United States, which the Supreme Court has enunciatedly said that the 14th Amendment has no such sort of provision, or it doesn't distinguish, and it has ruled that even children born in the United States to parents who are illegally here are citizens of the United States. So that's where it hangs in the balance. I didn't get an impression from anybody. Alito didn't seem all that up in arms in this case. Gorsuch asked, you know, whether to deal with this thing expeditiously or not. Then Kagan said, assume you lose on the merits. You took the injunction question, not the substance question. Every court has ruled against you. And then that question, the answer for that is, you know, you should just let the district courts do it as they're doing it. Let the issue percolate around in the district courts. And that these snap judgments that extend permanent injunctions on the whole country exceeds judicial authority. And so that's what was Barrett asked the question about whether the court should just let it go around. And then Sotomayor, or one of the liberal justices, I think, said that you would just let it just percolate for 2 or 3 years. So this issue that is of constitutional relevance, enunciated constitutional relevance in the 14th Amendment, just languishes, and we, in the interim, children who are born in the United States keep getting denied their citizenship. That's the question here. And we'll see how far the justices go. The way that the justices went, quick water break. Thank you so much for listening. Thank you so much for being here. I appreciate your comments. I know my viewership has gone down, but I'm going to keep on doing whatever I'm doing because I want to inform you about what is happening. And we see that there's a connection here in the AARP case and how there was an injunction put on the government to illegally remove from the country people who were named defendants in the AARP case. And that injunction rests on the violation of due process of law. So this case that has to do with the violation of another different constitutional provision would maybe even answer whether one ruling in a district court would equally apply to, well, no, doesn't matter in this case anymore because I guess the Supreme Court has ruled. So let me not jibber jabber, and I'll go now to the Supreme Court's case in the AARP versus Donald Trump. And there are many other plaintiffs, by the way. It's AARP et al., and AARP just happened to be the named plaintiff. And I think there was some gossip about whether AARP was happy about it or not. With that said, I'm going to read you excerpts from it that I think are important. One of the things that I didn't like is that this court, in this case, again, remands the case back to the appellate court, not to the district court, in order to apply this court's ruling. Now, the issue here is a little different from the previous case, obviously. And the Supreme Court remands this case, and that way, and I'll read you Justice Kavanaugh's concurrence, and I have to say, I can't believe I'm saying this, that I kind of agree with Justice Kavanaugh, although perhaps his final vote would probably be against what I would think would be the proper ruling, but who am I? So, the Fifth Circuit erred in dismissing the detainee's appeal for lack of jurisdiction. Appellate courts have jurisdiction to review interlocutory orders that have the practical effect of refusing an injunction. A district court's inaction in the face of extreme urgency and a high risk of serious, perhaps irreparable consequences may have the effect of refusing an injunction. Here, the district court's inaction, not for 42 minutes, but for 14 hours and 28 minutes, had the practical effect of refusing an injunction to detainees facing an imminent threat of severe, irreparable harm. Accordingly, we vacate the judgment of the Court of Appeals. And then they remand. The court then holds that the Fifth Amendment entitles aliens to due process of law in the context of removal proceedings. That's in a previous case, Trump v. JGG. We talked about that case before. Procedural due process rules are meant to protect against the mistaken or unjustified deprivation of life, liberty, or property. Due process requires notice that is reasonably calculated under the circumstances to apprise interested parties and that affords a reasonable time to make an appearance. Accordingly, in JGG, this court explained, with all 9 justices agreeing, that the AEA detainees must receive notice and they are subject to removal under the Act within a reasonable time and in a manner that will allow them to actually seek habeas relief before removal. The government has presented elsewhere that it is unable to provide for the return of an individual deported in error to a prison in El Salvador, talking about the Abrego Garcia case. The detainees' interests at stake are accordingly particularly weighty. Under these circumstances, notice roughly 24 hours before removal, devoid of information about how to exercise due process rights to contest that removal, surely does not pass muster. But it is not optimal for this court, far removed, and this part I don't agree, far removed from the circumstances on the ground, to determine in the first instance the precise process necessary to satisfy the Constitution in this case, meaning upholding the due process rights of these migrants whose legality are being challenged under the Alien Enemies Act. We remand to the Fifth Circuit. We did not on April 19th and do not now address the underlying merits of the parties' claims regarding the legality of removals under AEA. So I suppose this is only about the right to due process and how the Fifth Circuit didn't properly hear the interlocutory appeal because, as a practical matter, it is difficult to say that just providing 24 hours as time for due process is enough in these circumstances. So let's go back. A. Preliminary relief is customarily granted on the basis of procedures that are less formal and evidence that is less complete than in a trial on the merits. The purpose of the relief is merely to preserve the relative positions of the parties pending further proceedings. So it is not so much about the legality of the AEA removal, so much so as the core habeas claim of whether these detentions are constitutional or not, and whether there can be a preliminary injunction put in order to preserve the relative positions of the parties pending ruling by the court, pending proceedings. So the status quo is maintained while this case is being adjudicated in the courts, because otherwise it has real life impact on people who in this instance are getting illegally removed from the country, like the court points out in the Abrego Garcia case. Importantly, the relevant question for purposes of our jurisdiction is whether at the time this court was called upon to intervene, the district court's inaction had the effect of refusing an injunction. We had the power to issue injunctive relief to prevent irreparable harm to the applicants, and to preserve our jurisdiction over the matter. Now that the Fifth Circuit has ruled, our certiorari jurisdiction also supports review in the ordinary course. Finally, this court may properly issue temporary injunctive relief to the putative class in order to preserve our jurisdiction pending appeal. So it's talking about the Supreme Court is essentially saying we are now awake to your plans of trying to get these people out of this country before they get due process of law, and then just languishing them in the district courts, and we're not going to have it. That's just me commenting, not the court saying. Okay, back to the opinion. The named applicants, along with the putative class members, and Justice Alito points out that there is no class that has been certified yet, although they're talking putative class, meaning people who are similarly situated, detained in those locations under the Alien Enemies Act, and that's what putative means. So the named plaintiffs, along with putative class members, are entitled to constitutionally adequate notice prior to any removal in order to pursue appropriate relief. Although the putative class members may ultimately take different steps to protect their own interest in response to such notice, the notice to which they are entitled is the same. The application of an injunction pending further proceedings is granted. The judgment of the Fifth Circuit is vacated, and the case is remanded to the Fifth Circuit. In resolving the detainee's appeal, the Fifth Circuit should address, 1, all the normal preliminary injunction factors, including likelihood of success on the merits. So, as I said before, that's an important factor. As to the named plaintiff's underlying habeas claims that the AEA does not authorize their removal pursuant to President's 14th of March 2025 proclamation, and 2, the issue of what notice is due as to the putative class's due process claims against summary removal. So they're leaving that responsibility to the Fifth Circuit. And I don't agree with that, because I think every time you remand it, it gets diluted, and Donald Trump's DOJ takes the lower court for a spin. But this is an appellate remand, so we'll just have to see how the appeals court deals with the assessment of this injunction. Because the appellate court dismissed this case because they said they lacked jurisdiction. But now the Supreme Court is assuming jurisdiction of the case and saying, no, Second Circuit, you have jurisdiction, and now you must answer the substantive question of whether this permanent injunction needs to be applied to this putative class of people who are being detained under the Alien Enemies Act. Okay, the government is enjoined from removing plaintiffs or putative class members in this action under the AEA pending order by the Fifth Circuit and disposition of the petition for a writ of certiorari if such certiorari is timely sought. So that's the major ruling. And I'm going to read you a couple of parts of Justice Kavanaugh that sort of explains what happens with this case. The underlying legal questions that the courts may need to decide before the removals occur include whether the Alien Enemies Act, as distinct from the normal removal process under the Immigration Nationality Act, authorizes removal of these detainees. And two, if so, what notice is due before removal? Such federal district courts have already issued conflicting rulings on the underlying issues. The circumstances call for a prompt and final resolution, which likely can be provided only by this court. He's right. At this juncture, I would prefer not to remand to the lower courts and further put off this court's final resolution of the critical legal issues. Rather, consistent with the executive branch's request for expedition, I would grant certiorari, order prompt briefing, hold oral arguments soon thereafter, and then resolve the legal issues. I think that's a better way to go as well. But then Justice Alito has this really verbose dissent about how much time was given and how long it, whether the notice was given, and whether there was jurisdiction or not. Talking about what the evidence was that there was somebody that ICE had informed them that they will be deported either today or tomorrow, and that there was no specific evidence of, the time period. And he just goes on and on. I'm not going to go much into that. But effectively, he dissents, and so does Thomas. And with that said, we are going to have to see how the Fifth Circuit now applies the ruling on the injunctive relief that has been provided for these people who are being detained, and they were being illegally removed. And now they're not going to be illegally removed because of this ruling. But that doesn't mean these people are home free, because the Fifth Circuit can say, no, it doesn't. The injunctive relief is still wrong under these standards. And then it comes up to the Supreme Court, and they do grant certiorari, or they don't grant certiorari, meaning they don't hear the case, or they do hear the case. And what happens with these people? And my only thing is, this whole time, these people are being illegally detained. Their due process rights are being illegally violated, while this keeps languishing in the courts. And even if I believe that Justice Kavanaugh would eventually rule against the interest that I would rule for, I think his concurrence saying that we should expedite the process is the right process. Because the Supreme Court has the right and ability to do whatever the hell it wants. And that's just the basic truth of it. With that said, thank you for listening. Stay connected. Please like, share, and subscribe. It helps me out a lot. If you have questions and comments to this confusing reading, or maybe it's not confusing, let me know if it is confusing or not, and I can answer any questions that you have. Other than that, let's talk soon, and be safe.